Good morning and welcome to Law Talk with Ethel Mitchell. Now for today's show, here's attorney Ethel Mitchell.
Good morning. Welcome. I am your host, attorney Ethel Mitchell. Welcome to all who are listening live throughout the world on Radio 1 1450 AM, WOLDCnews.com, and LawTalkWithEthelMitchell.com. We have a great program for you today as we continue to discuss how the law protects creativity, and in particular, patent law and 3D printing, which is really hot. So listen and learn about information that can protect and benefit you and your loved ones. This program is brought to you by my law office, Wills and Trust, LLC, where I prepare wills, trust, power of attorneys, and advance medical directives. So if you or someone you know needs a will, a trust, or assistance administering an estate, call me at 202-772-1988. That's 202-772-1988. And I should also announce that beginning next week at 8:30, I will start a new radio program called Wills and Trust with Ethel Mitchell, where I will only discuss wills and trusts, power of attorneys, and invite your questions. So if you have questions about estates, about probating, about title to property and passing it on, listen in beginning next week from 8:30 to 9 o'clock. And then we will begin and continue Law Talk with Ethel Mitchell as we do each week at 9, from 9 to 10. You hear me say each week that law is powerful. It can help you or it can hurt you. It impacts everything you do. What you don't know can hurt you, but what you do know can empower you. So each week, Law Talk with Ethel Mitchell brings you lawyers and other professionals to share their knowledge and expertise with you. But remember, what you hear on this program is for information purposes only. No attorney-client relationship is established by anything said, and each person's circumstances are different, so you must seek individual counsel for any situation for which you need legal advice. All of our programs are archived at LawTalkWithEthelMitchell.com. So if you or a friend missed a program, go to LawTalkWithEthelMitchell.com and click on the button for archives, and all of the programs are posted there. My executive producer, Stacy Royster, are ready to receive your calls. Remember, this is a call-in show, so if you have questions, feel free to call in at 1-800-450-7876. That's 1-800-450-7876. So let's get started. Lately, we've been talking a lot about the importance of protecting your work and how to do that through intellectual property law. 2 weeks ago, we had a great program with Lita Rosario, the nationally recognized entertainment attorney and artist advocate, and with Professor Latif Mtima, professor at Howard University School of Law and director of the Institute for Intellectual Property and Social Justice, about copyright law and copyright recapture. We're going to expand the conversation this morning to include patent law and 3D printing. Our special guest today is attorney Darryl Motley. Let me tell you about him. Darryl Motley practices law in the Washington, D.C. office of Banner and Witkoff, Ltd. He provides strategic intellectual property law counseling in patent, copyright, and trademark cases, including opinions, licensing, and litigation. Mr. Motley holds a law degree with honors from the George Washington University School of Law, a Master's of Business Administration, and a Bachelor of Science in Engineering Science and Mechanics from Virginia Tech University. Prior to becoming a lawyer, Mr. Motley worked as an engineer in private practice and in the federal government, while also serving as a commissioned officer in the United States Air Force. Mr. Motley has been named an IP star in the United States and in the District of Columbia by Managing Intellectual Property Attorneys. Mr. Motley is a contributing author of the Annual Review of Intellectual Property Law Developments and the Public Contract Law Journal, both publications of the American Bar Association. He authored a law review article recently published in the Journal of Business and Technology Law entitled Intellectual Property Issues in the Network Cloud, Virtual Models and Digital Three-Dimensional Printers. That's what he's going to talk to us about today, because it's really exciting. Mr. Motley is a member of the adjunct faculty of the George Washington University Law School, where he teaches design IP law. He told us about fashion law. I never even knew there was law having to do with fashion. And he's brought a book for us that he contributed to called Navigating Fashion Law. That's exciting. He's also a member of the Council of the American Bar Association section of Intellectual Property Law. Mr. Motley is past president of the District of Columbia Bar, where he emphasized access to justice and pro bono services. Welcome. I'm really excited to have you with us today.
Thank you for that kind introduction. It's wonderful to be here and talk
about
these issues.
These are really exciting issues that are so current and affect so many different people.
They are. It's a wide-ranging issues, and it's a big industry that's coming out in 3D printing areas, and I'm looking forward to talking to you more about it.
Tell me, what is 3D printing? Because...
Yeah, 3D printing is sort of those areas where it's sort of, you think about a fax machine and paper, and people send a paper and put it in a fax machine. 3D printing is sort of the three-dimensional object part of that issue. So what happens is folks will scan different products, maybe your shoes, maybe your watches, eyeglasses, or whatever it may be, and scan those, and then they get sent into a computer system on your computer screen. Many years ago, it was sort of done with airplanes, large cars, but now we can do it at your home, pretty much, or with a mobile phone. And, so you take the picture. Let's say you look at a mobile phone. You take a picture of different products, your product, and then you can send it off to a service, and then a computer system will send back a picture. So I'll give you an example. Let's say you want to create a bobblehead.
Okay.
So you take a picture, let's say, of a person, take a picture, you send it up to a computer system, and the computer system sends back a nice little model of your picture you took.
So the actual three-dimensional model is created
digitally in a computer system, and then somebody takes it and they print it, and they call basically you print it or push it out into a little small computer system. So there's different manufacturers of these called 3D printers. There's some called MakersBot, Cubify.
Okay.
These printers, you can go to your local maybe library.
I heard the MLK library right here in D.C. has a 3D printer.
3D printer. So back in the olden days, let's say, we used to go to libraries maybe to read books and to print out paper or print out your reports. Yeah, your reports. Right. So now you can say, well, I'm going to make this, let's say, a new model of an object or a model on my maybe a toothbrush or something, maybe some kind of object, and I'm going to download it on my little thumb drive and take it over to my to the library
3D printer
and print it out.
And it's going to print out a toothbrush. It's going to print out an actual thing that you. Oh my God, that's amazing!
Could be a new watch, could be a new shoe, potentially.
It actually prints it in 3 dimensions.
3 dimensions. So these 3D printing objects have been used at Paris fashion shows. People have printed out capes, clothing.
What?
Hats.
Actually, I read, what is it called? Fast Company, the magazine?
Yes, absolutely, yes.
And about a month ago, they had their most creative people, 100 most creative people.
Yes, right.
And one of them was a young lady, I don't remember her name, but she actually printed out an engine from a Pratt Whitney.
Pratt Whitney engine, probably.
Yes.
Probably a jet engine.
Yes, yep. And she printed it out from a 3D printer.
In a little
That's amazing.
Tiny engine. Right, exactly.
That was just amazing.
And it didn't take much time to do.
Yeah.
So that becomes the issue of intellectual property issues that you can't print that out, right? You can just do anything you want.
Yeah. So what does the law have to say about that? Where? I mean, that has huge implications.
It does, and it's not a whole lot out there yet on the law about these issues. That's why there's an emerging issue that we need to figure out what to do. So to give you a little bit of ideas about what the law has about these issues, there's the patent side of the house, and, which I practice areas, and there's patent law, and then there's trademark and copyright law. I'll focus more on sort of the patent areas.
Okay, what is a patent?
So
tell us about that, because we've talked about copyright, but we haven't done much with patent. What is a patent?
Well, a patent is a product, a document that comes from the patent office that basically taught how to other users to make and use the invention. So if you have an invention and you had a patent, you can protect that product, and that way it works. So there's a couple of different types of patents. There's utility patents, and that protects how things operate and how things work. So that's what most people think of patents are. It's like, I have a new piece of software, and I want to make sure it works, protects how it works, so I don't want anybody to use how it works and copy how it works. I have a new kind of what's called widget, or some new kind of operation.
What about apps? If you create an app, can you get a patent on an app?
You can. You can protect applications, how they work and how they operate with utility patents.
Okay.
But you also can protect apps by how they look, by design patents, by the actual screen and users in the screen that's on the screen. Sometimes those applications, and sometimes those, we call it graphic user interfaces, those icons, could be patentable. People think they'd be copyrightable, yes, but they also can be actually a patent.
Okay.
Which is some of the new concept that folks on.
Yeah.
So you can protect the apps, and for design patents, that protects sort of how things look. The ornamental, we call it ornamental look, how things look, not how they operate, but how it looks. So you can.
Give us an example of the yoga pants story that you were telling us before the program.
Sure.
That's a good example of a design patent that I never knew about. Yeah,
this is it's a case for Lululemon yoga pants and Calvin Klein's, and in the fashion industry, there's different apparels and different aspects going on, and so in fashion and areas and apparel, a lot of people don't really think it's generally protectable out there. Well, how do you? I put a new fashion, and you see that it comes out the next week or next day if somebody else has done it. How do you protect that?
Pretty big.
What do you do about
business?
That?
Yeah.
So design patents are used to protect apparel and fashion. So on the yoga pants aspect, Lululemon came out with the yoga pants, and they had a design patent for it. But Calvin Klein came out with the same yoga pants that Lululemon had. Almost looked the same. And in that case, Lululemon probably wasn't very happy that Calvin Klein got that. And so they said, well, we have a design patent, by the way, on this design. And lo and behold, that case got settled very quickly.
So Lululemon had done the yoga pants. And had protected it with a design patent.
They did.
And so they were able to stop Calvin Klein
from doing
it. Oh, my goodness.
After a while, he said, well, Calvin Klein's no longer selling these pants anymore. It's not on the website.
And that's why.
And then that's the power of patents.
And that's what this show is all about, how to use the law to protect yourself.
And you can. And the thing is about designers, fashion designers,
they can do that.
They can protect their clothing with patents.
Wow. I never heard of that. For my listeners, if you're really interested in learning more, number one, if you want to contact Attorney Motley, he's at Banner and Witkoff at 202-824-3000. Their website is www.bannerwitcoff.com. And his email address is dmottley, DMOTTLEY, at BANNERWITCOFF.com. He's also on LinkedIn by his name, and his Twitter handle is at Darrell Motley. And Darrell is DARRELLMOTTLEY. I also want you to know that there is a book out called Navigating Fashion Law, and in it, Darrell has an article about tools for protecting fashion, the fashion law clients.
Yeah, that was a fun book to write.
That must have been fun.
Very fun.
That must have been.
Very exciting.
If you have any questions, you can call us at 1-800-450-7876. 1-800-450-7876. And I also want you to know, and I'm going to announce it again, the United States Patent and Trademark Office, which is the governmental facility that manages all of this, and the Prince George's County Memorial Library System are currently hosting a series of free workshops at the Oxon Hill Library, 6200 Oxon Hill Road, Oxon Hill, Maryland, 20745. There will be several intellectual property sessions covering patent, trademarks, and copyrights. The public, including inventors, makers, small business owners, and students, are invited to attend these free workshops. They will be held June 1st, 15th, and 29th from 6:30 to 8:45 p.m. You can register by calling 301-839-2400 or send an email to pr@pgcmls.info. Okay, so there are limited numbers of one-on-one sessions with the United States Patent and Trade Office staff will be offered each evening at 5:30. Advanced registration is required for all one-on-one sessions. So take advantage of this because that's huge.
I agree, and that's with the patent office. A few years ago, I used to actually go to the patent office, and they'd have inventor conferences, and I gave presentations on working with your patent attorney and kind of how patent attorneys can help individual inventors or companies too.
Okay.
And I think that's an excellent program because that's completely free.
Yeah, that is excellent. So if you are a friend of yours, are creative, they're writing music, they're designing fashion, they're doing apps, anything like that, making inventions, this is something you should definitely take advantage of. Definitely take advantage of. Now, tell me, Daryl, let's continue. What's the difference between a patent and a design? What's a design patent and what's a other kind of patent?
Regular patent.
Regular patent. Yeah.
Sure. Sure. Well, there's a couple different patents. Actually, there's patents for plants, which not many, but there's utility patents to protect how things operate and how they look, like the apps and software. But the design patent area is an area where pretty much how anything looks can be generally protected by a design patent. There's some different areas to look at. So design patents protect icons. You talk fashion. We can protect shoes. For example, shoes protect helmets, motorcycle helmets, for example. Headphones, microphones. TVs, computers. Pretty much anything you see and buy that you see that's out there in the store, you can protect with the design patent. You can protect. Generally.
And that's probably what you need to do in order to be able to sell it and commercialize it,
exactly.
to make it saleable. So who's the young man who got paid billions of dollars for some headphones recently? Hip hop somebody?
Dr. Dre. Maybe,
yeah.
And I'm sure
that was patented.
They have something on that. Exactly.
They would have to have patented that in order to be able to protect it.
Exactly, because it's a part of the patent system is helpful in businesses as well because it provides a kind of a envelope of protection for their products. So I'll give you an example. If Shark Tank is a very popular show, right?
Yes.
You see the Shark Tank out there.
Right.
These new entrepreneurs come in, and they come into these 4 or 5, Mark Cuban and them.
Right.
How much? They ask you, how much is your business going to be worth? Or how much you want? They want. Right? They always go, that's way too much, right?
Yes, always.
And the next question usually is, well, what makes your product proprietary? What is it that is going to stop that so nobody else can come in and copy it?
Okay.
And usually,
what do they mean by that?
And when they do that, they're asking about what is it that's a barrier to entry that somebody can come into your market to stop you? And then the entrepreneurs will say, well, I have some patents on this, or I have a patent pending, or I have a patent application. So these folks are important. They're smart. If they go into Shark Tank, they're really smart people.
Yeah.
Right? So they have some proprietary technology out there, and these investors, like Shark Tank, want to be able to know that there's some intellectual property protection that could stop others from coming into their market with the entrepreneurs having a new product.
Okay.
And so, and some of these some of these entrepreneurs have proprietary technology, they call it, because they have filed these patent applications, maybe have some patents on them. So it helps them, like the Lululemon situation, Calvin Klein, to stop people saying, "Oh, I can just take it and just copy it and sell it myself." Because, oh, by the way, no, we have some intellectual property here that we need to discuss.
Okay. Okay.
Just don't go on and take what we have.
Well, now tell me, for an ordinary person,
Right.
who has got this idea, maybe he's designed something, or she has fashion, or she's written something, or whatever, what is the process, and is it expensive to get a patent? What is that process?
Let's talk about the process, because I think that's a very important part, and that's what the patent office is going to try to talk about too. But this is important. We're talking about this as well.
Yeah, because and if you have questions, call in. I want the audience to call in, because this is a great opportunity to learn.
So
it really is. Yeah.
So let me give you an example of like anybody can be an inventor. So there's a story of a young woman now runs a company called Fresh Paper. She was an inventor at 14 years old.
Wow.
14.
Wow.
So she came up with a new idea about how to store and put products and put the chemicals. It's 14. Like, wow, she's genius.
Wow,
right?
she's smart. Yeah.
on paper and to store it. But so they contacted a patent attorney or a patent professional and how to do. So what we kind of do is we look and see, okay, what are you doing that's new and different than what's already done out there?
Okay.
Right?
So it has to be new and different.
New and different. So we'll search it. We'll have people to search and do what I call a patent search and see. Hopefully nobody's done it before, because sometimes things happen. So I had an inventor one time came up with a new spaghetti fork.
That's
new
different.
Spaghetti fork.
Hold on just a moment, Darryl. I think we have to take a break.
Sure.
And we'll be right back. Okay, sorry. We'll be right back, though. Hold it, okay?
1450 WOL, where information is power.
The Universal Circus is back, DMV, playing the National Harbor June 24th through July 19th. And we've got a deal of a lifetime that's sure to get your summers sizzling. Now through June 8th only, tickets to any performance of the Universal Circus are just $17.50. That's a savings of up to $8.50 per ticket. Just use promo code SOUL at Ticketmaster.com or Walmart. Certain restrictions and fees apply. It's today's entertainment at yesterday's prices at the Universal Circus. So don't wait. Get your tickets today.
Have you heard? Proactive Plus is faster and better than ever. Stay tuned for a $1 million bottle giveaway, and you'll also receive free shipping. With Proactive Plus, your acne can heal, and you can help prevent new breakouts. Don't miss this limited time offer. We're going to let 1 million people try Proactive Plus risk-free and get 2 free gifts, and also receive free shipping when you call right now. Call 800-489-0567. That's 800-489-0567.
Hey, there's my son. You've been in your room all morning.
Hey, Dad.
Matt, what's wrong with your voice?
There is nothing wrong with my voice.
Oh, well, it's just sort of.
I have been playing my video games and electronic games for so many hours.
Uh-huh. Well, it sounds like it might be time for you to take a break, or...
Hello, Dad.
Susan?
I have been watching TV and text messaging all morning. Yay, electronics. Yay, yay, yay.
Guys, I think it's about time to get in the car and take a little trip. Maybe see some trees, some green things.
What are these green things you speak of?
This weekend, unplug. Take your family to the forest. There's nothing in the world like experiencing nature firsthand. Trees, paths, bluebirds, streams. Getting closer to nature can get you closer to your family. To find the forest nearest you, go to discovertheforest.org. Brought to you by the U.S. Forest Service and the Ad Council.
When I grow up, I want to be a new pair of blue jeans.
When I grow up, I want to be a kid's first computer.
When I grow up, I want to be a glass countertop in a new home.
When I grow up, I want to be a kid's best birthday present.
When I grow up, I want to be a football stadium.
When I grow up, I want to be a warm place on a cold day.
When I grow up, I want to be a fancy backsplash.
I want to be a bike that races around the
When
country.
I grow up,
I want to be a bench on a forest trail. I want to be a rocking chair on a sunny porch.
I want to be a skyscraper.
I want to be.
I want to be.
I want to be.
When I grow up, I don't want to be a piece of garbage. And if you recycle me, I won't be.
Give your garbage another life. Recycle. Learn how at iwanttoberecycled.org. A public service advertisement brought to you by Keep America Beautiful and the Ad Council.
News Talk 1450 WOL-AM, where information is power.
Welcome back. You're listening to Law Talk with Ethel Mitchell. I am your host, Attorney Ethel Mitchell. We are having a very exciting conversation with Attorney Darrell Motley about patent and 3D printing and what the patent process is and how it works and how it can be used to protect yourself, your invention, and is very critical to your being able to make money out of some of these things. Yeah. So, and don't forget, please, if you have questions, call in 1-800-450-7876, 1-800-450-7876. So you were telling us about the spaghetti fork.
Yeah, the spaghetti fork.
Yeah.
So it's something where an individual inventor comes up and says, I have a new idea to figure out how to eat food, a new utensil.
Yes.
And so they ask, can this be patented? And it's important to ask before. And so there's a search, and lo and behold, there are hundreds and hundreds of spaghetti fork patents out there.
Are you serious?
There are so many spaghetti fork patents out there. I never knew that.
I was going to say, I never knew that.
I knew that. So, but eventually, once you see what's all out there, came up with a brand new design that no one ever seen for spaghetti forks, and he came up with a brand new patent, and he had it.
So he was able to get the design patent. Patent.
A regular patent operates. And it worked wonderfully well
because it was unique.
It was unique and new.
Okay.
And it was different from all the other spaghetti forks out there.
Okay.
So he's able to do that. So that's one example. There's many other examples to do this. It's new idea. Best to search and figure out. It's nobody else done it before because we don't want to really spend the time to do that. The patent office, once you file a patent application in the patent office, they will actually look at the patent application and your claims and I'll explain all these if you'd like to.
Okay. Well, we have a question. We have a caller. Arthur, are you calling from Connecticut?
Yes.
Welcome.
First time listening to your show.
Well, I'm glad. Thank you. Welcome.
I'm really enjoying both of you.
Well, good.
Thanks for having your guest. And, I want to ask you, it might be 3 questions, but you can answer it the way that to your expertise. On a design, something that's designed like in men's accessories, jewelry, is that a copyright or is that a patent?
Men's accessories jewelry, actually, it's an excellent question. It can be both, actually. You can protect jewelry as a work of art, as for copyright, and you can also protect it as a patented design for design patents as well.
Okay, very good.
Oh, okay, thank you. That's a lot of work. I'm sure at least you'll be protected all around.
Yes,
absolutely.
And the other one is something that you may have seen, but you see a different twist for it to use it a different way.
Give us an example, maybe. Do you have an example in mind?
Well, you mentioned let's say a fork, like you mentioned earlier, but my fork does something different that no one else is doing.
Yes, that's an excellent question again. The Patent Office allows you to make improvements of existing technology. And those improvements and those new twists and new ways of doing things can be potentially patented as well. So,
very good.
So that's an important thing as well in the patent system. It doesn't have to be completely new, no one's ever seen before per se, but that improvement of how things work differently, a new piece of item to add to something that item, and that addition can be also protectable, potentially protectable.
Wow. Very good.
Great,
Very good.
Great. And then also, I noticed I've watched the show, The Shark Tank, as well. I think it's a great show.
Absolutely.
Yes.
And oftentimes you'll hear about people that are just starting out, and in some cases, they're actually better off trying to put together a licensing deal.
Oh,
versus trying to manufacture it themselves and put it out in the market.
Yes, well, I mean, in the patent context, patents can be licensed as well, and they actually can be used with wills and as well as
it's an inheritable expense, right? Yeah.
Exactly. So licensing is something that patents can be licensed and how it can be used, and that's probably another show.
Yeah.
Oh, okay. All right.
But it's doable.
Yeah, absolutely.
Excellent. Thank you. Thank you very much, Arthur.
Okay, I'll
Thank
be
you
in
for your
touch.
call.
I'll be in touch with you, attorney.
Okay, very
you.
good. Very
Thank
good. We're talking with Attorney Darrell Motley about patent law and 3D printing. Give us a call at 202-486-61. I'm sorry, 1-800-450-7876. His information? Yes. Okay. Tell him how to reach you,
You can
Darrell.
reach me at 202-824-3142 is my office number, and my and one way to look me up for email is dmottley at bannerwhitcoff.com, BANNERWITCOFF.com. Another way to easily get me is just to www.dmotley.com. Will go right to my website. It's probably easier.
Okay. Okay, very good. Very good. Yes. So give us a call if you have questions, 1-800-450-7876, 1-800-450-7876. Tell us, Darrell, when you get a patent, let's say you go through the process of getting a patent,
Right.
what does that protect and how long does that protect?
That's a really good question. The on the utility patent side, it protects how it operates. And at the end of the patent, patent attorneys create these legal document called claims as part of the patent. It's sort of like your real estate deed, if you will. In a real estate, you have your deed to your personal your property. We have this deed to your technology, I'll call it. And the claims are sort of protects that technology legal technology that the patent office said it's okay to proceed with, and those claims protect that. So what patents do is basically stop others from making, using, and selling the technology in the patent deed claims area.
Okay.
And so you can use that. Licensing was a question about, so you can use a license and make the property as well. The term for utility patents is a little bit technical, but it's 20 years from initial filing. Let's just say it could be 20-something years old.
More or less.
Yes.
Okay.
On design patents, a little bit different. Same.
Are they renewable? I mean, before you go to are they renewable? Do they expire?
They do expire for the term.
For that term.
For that term. There are fees that the patent office charges to keep it alive after it gets patented.
After, okay.
Those fees, you can talk. It's a government fee that you charge for that for utility patents. On the design patent side, they are good for 15 years.
Okay.
There's no renewable. They're good for 15 always. They expire after 15 years.
Okay.
They do the same thing as utilities. They protect how to make and stop and use it as well. But it's how it looks.
Okay.
How it looks for the 15 years total.
Wow.
So it's a good time. You can have a long, decade and a half, 1 decade and a half of protection.
Yeah.
For design patents.
Now this is going to be strange. Can you patent or protect a recipe?
That's a very good question.
I'll tell you what I'm thinking about. Two different things. One is Coca-Cola. I mean, that has been around for a lot longer and for a long time.
That's an excellent question. Coca-Cola and when you talk, it uses trade secrets to protect their formula.
Oh, trade secrets.
So they don't want anybody knowing what they do, because on patents you have to disclose how to make and use the invention. So people see how to make and use it and get that term. But trade secrets, they can last forever. No one knows what it is.
Is it filed anywhere?
Stays in your vault.
In the vault. Okay. So it's just a secret.
It stays
you just don't tell nobody.
Don't tell anybody about it, right?
Interesting.
You can taste it. You know what it looks like, but you don't know what that formula is, right? You don't know how to do it. So.
But is it protected by the law? I mean, if somebody actually figured out how to do it, could they stop them?
Well,
if it's not.
Well, there's a case of folks that actually will take the trade secrets and take them and steal them from them, which is not a good thing. So there's laws prevent from taking trade secrets. But once it's not secret anymore, it's not. It's freely used to the public.
Freely used,
and that's the thing about trade secrets. You got to keep them secret. You don't want anybody to know about them. So we have special formulas or special ways of doing business. Okay. You may not want to tell folks how you do it, because then somebody else can do it, and then it's not.
So like all these chef shows that have you cooking different things with telling you what your ingredients are and so on like that, that's all out in the open.
It's on the open,
yeah.
I could be a good chef too.
Yeah.
I could try to be, I should say. Right, no, that's because they're giving out. Now with design patents, though, people have protected how the food arrangements are actually sold. There's actually how the actual food is arranged in a plate can be protected.
Oh, really?
If you're selling that way. So shrimp, there's a case of a shrimp case where shrimp has been arranged in a certain way with on arrangement of a plate. That can be protected.
That can be protected.
You can protect in food arrangements, cakes maybe.
Wow, that's different.
So it is different.
Okay, never heard of that. We have a call from New York. Is that not quite ready yet? Okay, well, let's continue, and we'll see. So you can protect your design.
Yes.
You can protect, I'm pretty sure you can protect logos.
Logos can be protected on a design patent sense as an icon on a computer screen.
Okay.
But you can protect it. Logos protected by copyright and by trademark.
By trademark also. So Louis Vuitton and Chanel and all these different logos.
That's on a trademark side.
That's the trademark side. Okay, very good. What about the design of the purse, for example?
Purse, that's design patent. I've done protections on purses before.
Okay.
That's an important.
That's an important one, I bet.
Absolutely.
Yeah.
Absolutely.
Is that what you use to stop counterfeiters?
That is one of the many tools to stop counterfeiters. As a matter of fact, our Supreme Court Justice Sonia Sotomayor was an IP professional.
She was, because I read her story. Yeah, I read her book, and she used to actually go down to, was it Chinatown somewhere, and they would raid these places and stuff. Yeah. That's a good book. If anybody's interested, you should get the book by now it's Justice Sotomayor. Yeah, that's a very good book. Yeah.
So design patents can protect counterfeit simulations of goods, because a lot of times the folks will take the logos off, so it'll look like the product. You'll know hey, that looks like XYZ company, but the logo's not on there. So you need to have the design patents to stop that particular aspect, because they don't know that it's a logo kind of aspect. So it's kind of like blending all these different areas together to try to help different companies, different inventors to start up. And
but as a practical matter, Daryl, fashion is so fast moving.
It is.
Okay, and so, every season you get a whole new set of designs. How does someone, or can you protect that kind of thing? Or is it just mainly designs that are vintage or something? I mean, what's the story there?
That's a good comment. The vintage designs were started somewhere, right? First.
Yes.
And they became popular afterwards. But
that's true.
Yeah, right? They became popular because of the sales and everything else. So what we try to say is maybe if you have lots of designs, pick your things that you think will be most popular, and you try to protect those because it depends on your budget and everything else. But the design patents in the last 15 years, right? That design that you have is going to be protectable.
It's going to protect it. At least you have that. Yeah, yeah. Let me repeat. There are free workshops being given at the Oxon Hill Library where the public is invited. There's several intellectual property sessions covering patents, trademarks, and copyrights. Inventors, makers, small business owners, students are invited to attend these free workshops. They're going to be held June 1st, June 15th, and June 29th from 6:30 p.m. to 8:45 p.m. You can register by calling 301-839-2400. You can send an email to pr@pgcmls.info. There are going to be limited one-on-one sessions with United States Patent and Trademark Office staff each evening at 5:30. You have to register in advance for that. But if you have some questions about this, that's an excellent opportunity to learn what you need to do.
I encourage you to go there because they talk about searching. They explain the one-on-ones are great because you can talk.
If you have a specific question,
do that. That's excellent.
And if you have young people, young adults, teenagers, some not even all that young, but they have all these wonderful ideas, just great ideas that could be protected. So I'm really doing this series to, one, inform people, but also to encourage people to really be supportive of a young person when they come up with ideas and they're trying to create things, and also know how the law can help to protect that.
Yeah, that's very good. And one thing, when you look at the countries around the world that have intellectual property protection, the good ones, we have the best, in my opinion, in the United States. But you see the economic development is from those protections.
Because
people invest money and invest into economies where they feel when they put the investment, they at least know that they can get some return on the investment. And intellectual property, like patents and copyright, trademarks, patents in general, allow folks to protect that investment.
Yeah.
So it's a big case. People have probably know about the Apple Samsung case.
That's a big one.
The iPhone.
That's a big one. Yeah. So tell us a little bit about that, because those are big ones.
Sure. In that case, it's primarily all about design patents. Apple came out with their new iPhone at the time, filed design patents on their mobile phone at the time, and
they file all that before they sell it, don't they?
They file all before, right?
Okay.
We always suggest you file before you sell, and keep it there because you have global rights as well. When you file before you sell and before you disclose it, you have global rights around the world to do that.
Oh, really?
To do that.
So our law can be enforced in China and Japan and Africa and all over the place?
In a way, it can be. What happens is once you file in the United States, you have what we call rights of priority, that you can extend your rights around the world as long as you haven't disclosed prior to it.
I see.
There's the technical issues about disclosure, but you can extend your rights for a limited period of time around the world. We call claiming priority back to the United States for your initial filing. So, but you have to go under the laws of those particular countries.
I see.
To do it, but they recognize the U.S. rights, and it's been around for a while. But that's something that can be extended.
That can be done. Right.
Around like almost every country in the world, you can do it if you really want to do it.
That's great. That's great. So tell us more about Apple and Samsung.
The Apple Samsung, basically, to make the very long story short, because it's a very long story, is Apple comes out with a new product, iPhone. They file design patents on it and get protected. And then Samsung had phones prior to when the iPhone came out. And the long story goes is that after the iPhone came out, the Samsung phone started looking a lot like iPhones.
Okay.
And many people.
Lo and behold.
A lot of folks noticed that. You don't have to be an attorney. You can be someone going go in your local store and go, "Oh, yeah, looks like an iPhone." So Apple said, we can't allow this. We can't do that. You can't take are in designs that we've done and printed up, and you can't just use them without copying them. So they had a long battle around the world, but a few years ago, the a jury in California, because they filed a lawsuit and said, by the way, Samsung, you have infringed Apple's design patent on the iPhone.
Right.
And that's gone through many different aspects, different parts of the case. And recently in the Federal Circuit, it's our court here and locally in D.C. And said, yeah, we agree that Apple, the design patents, you did infringe them.
Okay. That Samsung did infringe.
Apple's design patents. And so they were stopped. So they basically had to going to pay Apple $500 million.
$500 million.
Or
wow,
more,
that
or
is
more.
serious money.
Yeah, exactly.
Yeah.
All from a little design patent.
Wow.
People don't really realize existed.
Yeah. So
time.
you really just can't take people's stuff and copy it if they've protected themselves.
If they did it, yes, we suggest that you avoid doing that.
Yeah.
Avoid doing that. And sometimes, sometimes people don't know. Sometimes people will take their patents and say, "Well, I covered everything in the world," because we also defend people that people say, "Well, you infringed my patent." Like we go, "No, you didn't." But there's a technical reason how we do that. But we also look in the side too that people will assert patents they think will cover everything in the world. I use this term everything in the world, but they'll say they cover. It looks exactly the same. Well, it's nothing like it, but they say it does, and we go, we need to just this. You guys have gotten too broad coverage. Or you think you're too much, but this is some of the parts. What we do as attorneys is we help people get patents, and also when people have patents and people say, "Well, you potentially infringe," we also help them defend them as well.
Okay.
Try to see if that's really
it's
right or not. Not a issue.
This whole area is just fascinating. I mean, Lita had also come on. Lita Rosario, the entertainment attorney, came on several months ago when Blurred Lines had just come out.
Oh, that's right. Oh, yeah?
Yes.
Big case.
Big case, right. And she talked to us about how the Robin Thicke and Farrell had this song that sounded so much like Marvin Gaye. And,
very similar.
And what was weird to me was that they sued Marvin Gaye. I don't know if people realize that. She was saying that they sued Marvin Gaye, and I'm like, that doesn't make any sense. So, of course, Marvin Gaye sued back, the estate came back, really now,
Right,
and $8 million later,
Yeah, that was a jury case. That was people that were regular citizens sitting in the courtroom saying, this sounds a whole lot similar.
Yes. But she also talked about how they had expert musicologists who were able to specifically show what was unique about Marvin's music.
And they copied that unique
And they
part.
had copied those unique parts. Yeah. And then I think last week we also talked about her article about that. But the whole idea of this whole series is that people can be protected when you invent things.
And that's in toys, potentially toys.
Yes. The young man we were talking during the break about is he an engineer?
Super Soaker.
Super Soaker. Yeah, he got like $73 million.
Yeah, and that's from the patent side of protecting the actual patent.
So he had gotten the patent for it ahead of time,
because
right?
you don't want anybody just to take it and just copy the product, right?
And that's exactly what they had done, even though he had the patent on it. Yeah.
And that's what the patent's there to help protect that part of it. You also can get fees back, and we call royalty damages back. That's what by copying something you shouldn't be copying.
Right.
So these patents, the federal government allows you to do this. That's our Constitution. Patents are protectable. To do that. But
I never realized how important they were, I must say.
And most people think you have to be, a PhD or some technology people. You don't have to be. Any everyday person can come up with a new idea and say, "Hey, I come with a new idea to do something," and you never know. It could be.
It could be, and there you get a stream of money and income coming in. And I just want to remind people that 2 weeks ago we had a program on copyright recapture, where even if you signed over your copyrights, that was mainly in music, although I'm not sure it's restricted to that. there is a provision in the copyright law that Attorney Rosario talked about where you can go in and recapture. In other words, you can get them back. But there are some time limits that are coming up. I think it's like 25 or 35 years, and there's a way you have to do it. So know that, and please remember, you can get a lot of information from the U.S. Patent Office, June 1st, June 15th, and June 29th. We have a phone call. Cheryl?
Yes. I was going to ask a question relative to what you just talked about with the Marvin Gaye situation. And I'm glad that his people won that. But can he go into a little depth on it? You know, was he well protected or what?
Well, I think what you're going to have to do, well, Darryl, you're welcome to.
I can talk a little about it if you like.
Oh, okay, yes, okay, fine.
Yeah, the copyright law, music's protected for a very long time. And in that case, basically, if you're going to copy the music, the copyrighted music, and you can say he was well protected because at the end of the day, there was an infringement.
Yeah,
and I got a good award for that amount from the judge. So if you go onto YouTube, there's and type Marvin Gaye blurred lines. There's these different YouTube videos out there that will blend them together, and actually there's one that will blend the two together, and it almost sounds the same both. And I could see why they thought it was infringed, because when you start playing them together, you go, well, that sounds almost exactly the same.
Yeah, I think Darryl's played that for us when we had that program. He played some part of that. Yeah. Our engineer did that for us. So it's important that you protect yourself. I think that's the bottom line.
Did that answer the question for you?
Cheryl, is that?
Thank you, attorney.
Okay, thank you. Thank you very much. We're going to really tell you thank you, and I promise to have you back.
Oh, I'm pleased. Thank you. It's been very fun to talk.
Oh, my goodness.
There's a lot of different issues in this area.
Yeah, there is, and there's a lot of new stuff that I'm fascinated by with that I'd like to share more of what you're talking about in the cloud, virtual models, fashion law. I mean, that's a whole area I never even heard about before. So we are going to have you back, definitely. I'm looking
happy to please to talk to you more about it.
Definitely. Thank you very much. Again, my listeners, you can contact Attorney Motley by going to, give us your website again. That's probably the easiest way.
www.dmotley.com.
And spell your last name.
Yeah, DMOTTLEY.com.
Okay.
And it'll go right to my firm's website. And it's easy, and you can get my phone numbers are there and everything else.
Okay, very good, very good. And don't forget to go to the Oxon Hill Library if you're in this area, June 1, 15th, and 29th. It is free, given by the United States Patent and Trademark Office. If you have any questions, you can bring your stuff there. You can ask about it. If you've got music, you've got art, you've got all kinds of things like that. Make sure that you take advantage of this. And I understand from Attorney Motley that they have these sessions at different times. Okay.
Probably around the country as well eventually. So, but this
this one is right now. And as I look at the programs, there's patent for beginners, trademark for beginners, copyright for beginners, one-on-one sessions, how to file a provisional patent application, choosing the right logo for your business, filing a copyright application, patent search strategies, elements of the patent process, creating an effective trademark, strategies for your business, and important issues for authors, artists, and makers. So that's going to be excellent. It really is. Make sure that you are going to take advantage of that. As I close now, remember next week to tune in earlier at 8:30, where I'm going to inaugurate my new program where I invite questions about my particular area of the law, wills, trust, estate planning, how to transfer your assets at the time of your death, how to protect them while you're alive, how to protect yourself, how to make sure that your children's money is used in the way that you want it to if something happens to you. What are the issues of being able to avoid guardianships and some stranger taking over your money if something happens to you, if you become incapacitated? How to protect your family with title. That's a huge one, because people do things when they get married to somebody new that may disenfranchise their children. I mean, it happens all the time. People walk into my office and they find out that, oh, I got married, so I put somebody's name on my deed, and then you die, and then your children can't get any part of your property. So we're going to talk about all these different things. We're going to talk about probate. So tune in 8:30 to 9. We're going to be available. I'm going to be available to answer those kinds of questions and to talk to you about that. And we will have another excellent program on Law Talk with Ethel Mitchell from 9 to 10. So have a good week. Goodbye.
You've been listening to Law Talk with Ethel Mitchell. Be sure to tune in next Saturday at 9 a.m. for another informative broadcast. To reach Attorney Mitchell, you may do so by calling 202-772-1988. That's 202-772-1988. Or log on to her website, www.lawtalkwithethelmitchell.com.